Introduction to Criminal Investigation, Chapter 1. Etymology of Criminal Investigation. Investigation. The word investigation comes from the Old French investigation, which means a searching into, and from the Latin word investigationem, which means a searching for. Concept of investigation. Criminal investigation as an art. It is considered as an art because it is not governed by rigid rules or fixed legal procedures, but most often based in institution and sometimes by chance. Balik. Criminal investigation as a science. It is considered as a science because it involves the application of knowledge of forensic science in the process of identifying, locating, collecting, processing, and or evaluating physical evidence. Criminal investigation as a process. It involves the systematic process of identifying, collecting, preserving, and evaluating data or raw facts to produce valuable information to prosecute a criminal offender that eventually leads to proper administration of justice. Criminal investigation is a collection of facts in order to accomplish the three-form aim. Number 1, to identify the guilty party, to locate the guilty party, and to provide evidence of a suspect guilt. Law Associate to Investigation, 1935 Philippine Constitution, Art 3, Section 17. In all criminal prosecution, the accused shall be presumed to the announced until the contrary in provide, and shall enjoy the right to be heard by himself and counsel, to be informed of the nature and cause of the accusation against him, to have speedy and public trial, to meet the witness face to face, and to have compulsory process to secure the attendance of witness in the behalf. 1987 Philippines Constitution, Art 3, Section 12. 1. Any person under investigation for the commission of an offense shall have the right to be informed of his right to remain silent and to have competent and independent counsel, preferably of his own choice. If the person cannot afford the service of counsel, he must provided with one. These rights cannot be waived except in writing in the presence of counsel. 1987 Philippine Constitution, Art 3, Section 12. 2. No torture, force, violence, threat, intimidation, or any other means which vitiate the free will shall be used against him. Secret detention place, solitary, incommunicado, or other similar form of detention are prohibited. Number 3. Any confession of admission obtained in violation of this or Section 17 hereof shall be inadmissible in evidence against him. 1987 Philippines Constitution, Art 3, Section 12. 4. The law shall provide for penal or civil sanctions for violation of his sections as well as compensations to and rehabilitation of victims of torture or similar practice and their families. Related cases, Miranda 5, Arizona 1966. It came from America jurisprudence. A Latino named Mr. Ernesto Miranda was arrested for the crime of rape and kidnapping in Arizona. The Arizona police interrogated Mr. Miranda, which led to his confession. Mr. Miranda's confession led him to convicted of 2 crimes accused to him. Mr. Miranda filed an appeal before Arizona Supreme Court but lost the appeal. He then raised up his appeal to U.S. Supreme Court, was acquitted on the grounds of violation of his constitutional right. Related cases: Miranda 5, Arizona, 1966. Miranda warning. You are arrested for the crime of or by virtue of warrant of arrest, showing him the warrant as a practicable. You have the right to remain silent. Any statement you may use for or against you in any court of law in the Philippines. You have the right to have a competent independent counsel, preferably of your own choice. If you cannot afford service of counsel, the government will provide one for you. Do you have understand these rights? Ikaw ay inaresto sa salang paggamit ng kautusan. Opportunity. It refers to the chance given unconsciously by the victim to the perpetrator to commit the crime. These are the acts done by victim or situations occurred that attracts the perpetrator and gives the chance of victimizing the victim. Goals of criminal investigation: to determine whether a crime has been committed. Number 2, to legally obtain information or evidence. Number 3, to identify persons involved in the crime. Number 4, to arrest suspect. Number 5, to recover stolen properties. Number 6, to present best possible case to the prosecutor. Objectives of the criminal investigation: to establish that a crime was actually committed. Number 2, to identify the suspect. Number 3, to recover stolen properties. Number 4, to assist in the prosecution of personal change with the crime. Phase of investigation. Phase 1. Identify the suspect: truth, confession, admission of suspect on the offense committed. An excellent means of identification. Eyewitness. Made by several objective persons who are familiar with the appearance of the suspect, who personally witnessed the commission of offense, and who have personal knowledge of that happened. Number 3. Circumstantial evidence. Established directly by providing other facts or circumstances which, either alone or in connection with other facts, the identifier of the perpetrator may be established. Links a suspect with a crime. Phase investigation. Phase 2. Locate apprehended subjects. The crime perpetrator may not operate nearly his residence. His flight from the scene merely a return home, unless he is recognized during the commission of offense. Phase 3. Gather and provide evidence to establish the guilt of the accused. The investigation must be competent in finding relevant evidence. The criminal case physical evidence can be found at the crime scene. The criminal investigation. Criminal investigation. It is a law enforcement officer who are trained, disciplined, and experienced to conduct criminal investigation, and the one who carry the objectives of the criminal investigation. Investigator. It is one who gather documents and evaluate evidence and information. This accomplished through process of investigation. Investigator must be equipped with essential qualities such as good communication skills, strong ethics, initiative, resourceful, and compassion. Characteristic of criminal investigation: knowledgeable. This refers to the investigator who exhibit understanding about crimes evidence, law, to include the suspect and the victim. Number 2. Perseverance. Refers to the steadfastness, persistence, and resolution to bring the desired conclusion of spite or obstacle connected with the criminal investigation. Number 3, endurance. This refers to the ability of investigator witness hardship in the conduct of investigation to include ability to last physical and mentality, honesty, and integrity. Number 4, the investigator must always observe the moral conviction of doing the right thing in all circumstances. Characteristics of criminal investigator. Number 5, intelligence and wisdom of Solomon. This is very important in order that the investigator could easily decipher falsehood and truth, separate and the remain from chaff of King Solomon did when settled dispute of child ownership between two mothers. Number 3, acting ability is the ability to go down to the level of subject minors, the prostitute, or the slum dwellers, or the levels of other professionals or the members of the elite. Number 7, good in oral writing communication. This is the ability of the investigator as mingle with the community to include the making concise report. 8, the keen power of observation and description. The investigator shall be good in observing and describing the things around him. Number 9, characteristic of criminal investigator. Number 9, courage. It's the moral fortitude to tell the truth no matter who will be hurt. Number 10, the power to read between the lines. It's the ability of the investigator to interpret the words, phrase encountered in the process of investigation in their deeper meaning in order to arrive which concrete meaning of the certain statement. Number 11, knowledge in martial arts and firearms proficiency. This will help the investigator defining himself with confronting, arresting, and interrogating the subject. Primary job of a criminal investigator. The primordial responsibility of an investigator is to unfold whether or not an offense has been perpetrated under the law. After determining what is specific offense was been perpetrated, he must discover how it was perpetrated through its six cardinal points of investigation. Six cardinal points of investigation. Number 1, what specific offense was committed? Number 2, when it was committed. Number 3, where the offense was committed. Number 4, who committed it. Number 5, why it was committed. Number 6, how the offense committed. The three tools of its criminal investigation. Number 1, the knowledge of facts that investigator ungathered or acquired from person or document which are patient or relevant concerning the commission of a crime criminal activities. Information classified as to its source. Number 1, regular source. Records, files from government or non-government agencies, news items, TV broadcasts, intercepted radio, telephone message, and stored computer data. 2, qualitative source. Information furnished by informants of or informers. Grapevine source. When the information is disclosed by underworld characters such as prisoners or ex-convicts. Rights of the person arrested. Detained or under custodial investigation. Any person arrested, detained, or under custodial investigation shall at all times be assigned by counsel. Any public officer or employee or any acting under his order of his place who arrests, detains, or investigates any person for the commission of an offense shall inform the latter in language known to and understand by him of his rights to remain silent and to have competent and independent counsel preferably of his own choice, who shall at all times be allowed to offer privately with the person arrested, detained, or under custodial investigation. Anatomy of crimes. Motive is defined as a reason which pushes a person to commit an act with a definite result in mind. Instrumentality. It is the means or way of the perpetrator in committing crime. This may be the objects that aid the
Methods of crime scene search. Number 1. Strip method. So the strip method is where the searchers proceed slowly but in parallel in the crime scene place, and they turn and repeat the process of investigating until they covered all the crime scene place. Number 2. Double double strip method or grid method. It is the same as the first method, but as what its category says, it's double. Number 3. Wheel, radical, or spoke method. The third method is where the searches should be at the center of the area and repeat it based on the size of the area. Number 4. Spiral method. The fourth one is simple as its category says. Searchers must start outward and begin spiraling towards inside and must follow the same path for the other searchers. Number 5. Zone method. Zone method. A searcher divides the area and assigns one searcher to investigate every quadrant. General kinds of sketch. Rough sketch. It is made by the investigator at the crime scene, which is full important details. This is used as the basis for the finished sketch. So, rough sketch is usually used as a primary information for the finished sketch, which it contains the recovered items or physical evidence, distance objects. Each item is assigned a letter or number. The sketch shows compass heading designating north. Finally, number 2 is the finished sketch. This is sketch with a scale and proportion drawn by a draftsman. The rough sketch and the finished sketch are for courtroom presentation. So it is like the full detailed sketch in the crime scene. Parts of sketch. We have the title. It refers to the crime committed or the incident happens as vehicular accident. The body. It refers to the sketch proper to include the position of the victim and other items in the crime scene. Compass. Standard arrow to indicate the north direction. Parts of sketch. Nature of case. It refers to the status of the case whether currently committed or days have passed. So it is like a timeline. And then location of incident, date, time. So a sketch should contain all these details or components. So the searchers must gather all the information they needed. And then parts of sketch. Number 8, name of suspect, legend, signatory, also the date and time. Elements of sketching. Measurements. So the measurements must be accurate. This will be based on the crime scene area. Compass direction. The compass is used to determine north. So siya yung nag-determine ng mga distances ng mga possible na mga evidences kung saan nakalocate sa crime scene area. Essentials. The sketch should portray these items which have bearing on the investigation being conducted. Essentials means yung mga collected possible evidences na included sa crime scene. And then scale proportion, the actual or approximately scale sketch should always be shown by words and figures graphically. So, kailangan visible and understandable yung pagkakagawa ng sketch, and then yung mga informations, then the legend, explanation of the symbols, title includes case identification. Examples of a sketch, elements of sketch. The specific kinds of sketch. Sketch of locality. It deals with the vicinity of the crime scene in relation to the environs. So, kung saan siya naganap at yung mga structures na nakapalibot for yung event. Sketch of grounds. Yung sketch illustrates the scene, the nearest physical surroundings, such as room adjacent or opposite of floors. Then, sketch of details, it includes the positions, measurements, illustrates all the possible information that will be needed by the search. Custodial investigation. It is the term denote the investigation conducted by the investigator, the suspect who is under police custody. This is the stage. Confession distinguished to admission. Confession. It is the declaration of the accused acknowledging his guilt. So it is like the stage where the suspect or the witness is exploiting all the informations or all the hidden possible informations about specific crime scene. Admission. It is the acknowledgement of fact or circumstance without accepting guilt. Self-incriminatory statement by the suspect falling short of an acknowledgement of guilt. Kinds of confession. Extrajudicial confession. So, ito yung mga klase ng confession na wala pa sa court, pero yung suspect sinasabi niya lahat ng mga nalalaman niya sa isang crime scene. Judicial confession, just made by the accused in open court. The plea of guilt may be made during the arraignment or any stage of proceedings where the accused changes plea of not guilty to guilty. So, dito na papasok yung hearing kung whether mahatulan siya ng guilt or not sa mga siguro sa isang specific na crime. Kinds of extrajudicial confession. Voluntary extrajudicial confession. So, from the word itself, voluntary. So, the witness or the suspect itself might voluntarily exploit or spill the information without any question or permission of others. Involuntary extrajudicial confession obtained through force. So, ito yung ginagamitan na ng force, like yung needed na talaga, like kung kailangan na talaga nilang makukuha na information galing sa isang suspect, so they need to use force. The technique of interrogation, emotional appeal. This is a technique where the investigator combining his skills of an actor and psychologist